continuing production of The Open Mind has been made possible by grants from Ann Olnick, Joan Gans CUNY, the Engelson Family Foundation, Alfred P. Sloan Foundation, the John S. and James L. Knight Foundation, Carnegie Corporation of New York, May and Samuel Rudin Family Foundation, Joanne and Kenneth Wellner Foundation, Rosalind P. Walter Foundation, and from the corporate community, Mutual of America.
I'm Alexander Heffner, your host on The Open Mind. We continue today our ongoing 60th anniversary series. Democracy and free speech are the subject, and we're honored to welcome the founding director of the Knight First Amendment Institute at Columbia University, Jameel Jaffer. The mandate of the Knight Institute is to preserve First Amendment rights in the digital age through research, education, and litigation in favor of protecting freedom of expression and the press, including the legal defense of whistleblowers. Previously, Jaffer served as the Deputy Legal Director at the ACLU and led its Center for Democracy focused on national security, human rights, free speech, privacy, and technology. Jameel, congratulations on your new post.
Thank you.
What I wanted to start here with is something rather timely. This question of what is permissible in the digital age with respect to leaks, with respect to journalistic endeavor, with respect to the law. Is WikiLeaks at this juncture, as Edward Snowden himself has identified, injuring its own cause? It's enabling the kind of reckless behavior that those who are critical of these kinds of leaks point to as why it should be unlawful, or why what Snowden did is traitorous.
I would separate two questions, as I think you did in your question: the question of the law and the question of whether what WikiLeaks is doing is injuring its own cause, which I think is a separate question from the legal question. On the second question, I have not agreed with every disclosure that WikiLeaks has facilitated or made. Even from the beginning, I had reservations about some of their disclosures. But the truth is, I have reservations about many things that are published in the national newspapers, and that's a very different thing than to say that they don't have the right to publish them. So that's why I say that the legal question is a separate one, and it's important to keep it distinct. On the legal question, the truth is that there's a lot of uncertainty about how the law will apply to situations like this. I mean, there are these precedents like the Daniel Ellsberg precedent. There are many other, precedents that have some bearing on the WikiLeaks situation. But many things have changed since those precedents were set. For one thing, WikiLeaks is a transnational organization in the way that some of the other media organizations weren't 50 years ago. For another thing, the scale of the leaks is different. The nature of the abuses being disclosed varies from one context to the next, and that may be important because once the law in this area is settled, it may matter whether any particular disclosure was made in the public interest. And by that, is one of the things that Snowden has said, that he would actually come back to face trial in the United States if he could make the argument to a jury of his peers that his disclosures were in the public interest. And so, one day, if WikiLeaks faced that kind of prosecution, would it be able to claim that its disclosures were had been in the public interest? That's an important question. So, I realize that was just a long way of not answering your questions, but I think that there are two separate questions, and both of them are hard.
Well, let's interrogate each one, right? So, from the outset, I think I wanted to clarify for our viewers, when you're referring to the substance of the disclosure, you're saying, is it public corruption or is it social snark, innuendo about relationships of private people? And that seems to be the point.
I think that those are certainly two considerations, right? You know, or one consideration. What's the nature of the disclosure in that sense? I'm not sure that I would limit the universe of legitimate disclosures to public corruption, right? I think the most significant thing about Snowden's disclosures was not that he disclosed legal abuses in the sense of individual executive actors going beyond what the law permitted. The main significance of Snowden's disclosures was that he disclosed the extent of what the law permitted. You know, I've said this before, but and other people have said it long before me. But the scandal here was what was legal, not what was illegal. The scandal was that the NSA was allowed to do all of this, and that's what Snowden disclosed. So, and I think that was, I think that those disclosures were in the public interest. Snowden's disclosures. So that's why I say that public corruption isn't broad enough to describe the universe of disclosures that I would argue should be protected by the First Amendment. But more generally, I think you're right that you have to distinguish between disclosures that are in the public interest and disclosures that are in the public interest and the disclosures the public interest outweighs the private interests that are compromised, and disclosures where the balance comes out the other way.
And there's a differentiation we can draw between behavior that would be inconsistent with the law and behavior that is personally uncivil. If you look at the example of the Podesta emails or other correspondence, and I'm sure if you looked at RNC incoming mail, you would see the same kinds of examples of political maneuvering, uncivil behavior in the language that folks are using in correspondence. But let's talk about that second dimension of this issue, which is how in the digital age we're going to define the parameters of what is permissible. And that is this idea of a transnational organization. What I find interesting about this is, as Justice Breyer has pointed out, it is an unknown. It is a great unknown, but it's more important than ever to understand how we can set international law, not just in terms of human rights violations, but in terms of this kind of discussion of the First Amendment. Where do you see the possibility to bring together the globe to manage what would be free speech or speech that crosses the line, but what are the channels through which there can be international consensus around this? International consensus may be too much to hope for or to expect in the short term, right? I mean, the truth is that the United States has been a leader on free speech issues in particular for many decades, and not everybody sees free speech in the same way that we do here. The courts in other major democracies don't necessarily protect speech in the way that American courts do. And in many of those democracies, citizens are quite happy with the balance that their courts have struck. So I'm not sure that consensus is reachable in the near term. But I do think at the margin, we have free speech advocates here in the United States have an obligation to push the boundaries elsewhere. And that's not so much a kind of colonial project as a recognition that our rights are intertwined now, right? The free speech doesn't end at the border. It travels, in both directions across the border, and the restrictions that governments elsewhere place on speech have an effect on both what we can say and what we can hear. And I think that companies like Google and Facebook and Twitter are quickly finding out that
it matters what you may be based in the United States, but it matters what European governments, what Asian governments think, because they can place restrictions on what their own citizens can see, and less directly, they can place restrictions, therefore, on what you can broadcast. So, I think the borders, there's no bright line at the border anymore. If there, it probably never was, but that line has become much blurrier over the last, over the last 20, 30, 40 years.
And we don't necessarily have a consensus in this country either.
Right.
Half the country views Edward Snowden as villain, half as hero. Generally, there is a split. It's not a unanimous verdict on a whistleblower. You wrote in a recent lecture, the Peter Zenger lecture, A First Amendment in the Digital Age, our age will give rise to many novel and vexing questions relating to the scope and substance of First Amendment freedoms. One reason for this is that the Supreme Court's seminal cases relating to the freedoms of speech and the press, the cases that shape our public spaces and public discourse today, were decided a half-century ago. And then you continue. They were decided before the advent of social media, and before the very visible connection that we see, not only in terms of freedom of speech in the U.S. to freedom of speech elsewhere, but freedom of speech here to freedom of domestic tranquility. And those who view Snowden as either criminal or traitor or wrong do most often because they view him, and the president said the same thing upon awareness of the disclosure, as a threat to national security. So we saw here in New York and New Jersey that in the case of the Chelsea bomber, there was a very expeditious law enforcement effort that ought to be applauded. It was made possible because we've installed cameras on the streets.
Right.
We have no certainty of privacy as soon as we leave our apartment. In the case of a major city, whether you're in St. Louis, Orlando, San Bernardino, those were some spaces that were affected in this way. So when you talk about the advent of these technologies as being critical in determining what the law is, what the jurisprudence is, how does the law factor in these real-life consequences of privacy versus security?
Yeah. Well, I mean, so a few things. One is the law inevitably lags behind the technology, right? The technological change is much quicker than legal change, and so the courts are always playing catch up, and really, it may be unrealistic to think that it's possible for the courts to sort of catch up to technology. Really, what the courts have to do is set markers. They have to make statements that affect technologies that they can't even predict at the time they write those opinions. They have to set markers in terms of our values, in terms of the trade-offs that we're willing to make as a society, in terms of the meaning of constitutional protections. They set these markers, and then technology gets ahead of the markers, but the markers have ideally have a kind of continuing effect on the development of the technology and the direction in which we sort of head. I think that's the most you can hope for from the courts. I think you're starting to see that with some of the technologies that you mentioned. There was a case in U.S. versus Jones, a 2012 case, in which the court held, it was a split decision, but the court was in agreement that location tracking, the installation of GPS devices on individuals' cars, and continuous tracking of an individual over an extended period of time was a sufficiently invasive search that it required probable cause and a warrant. And that is. Depending on how you interpret the opinion, that is perhaps a little bit of pushback on this idea that once you step into the public sphere, everything is fair game. You have no reasonable expectation of privacy left, because here the location of this person was in fact in the public domain in some sense. They could have tailed his car. the police could have tailed his car for that extended period of time and collected the same information. But the court said, you know what, this GPS tracking is much more intrusive than, as a practical matter, much more intrusive than what the police could ordinarily do, certainly what they could ordinarily do cost effectively. And the court sort of drew a line. And I think that that's an instance of the court seeing the development, not just the development thus far of this kind of privacy intrusive technology, but the direction in which that technology was headed, and putting down a marker for privacy. Basically reclaiming a little bit of the privacy that the court had given away in previous cases. So you see it a little bit. That's a Fourth Amendment case. It's not a First Amendment case. It's closely connected to First Amendment rights. But so far, there have not been a lot of cases in which certainly the Supreme Court has grappled with the First Amendment implications of new technology, the free speech or freedom of expression implications of new technology. And all of this technology, I think, does have a very real effect on those rights, on the right of speech, right of association, rights of the press. This is not a new idea. It's something that you can find in the case law going back, certainly at least 50 years, a recognition of the implications of government surveillance for the freedoms of speech in the press and association. In fact, there's this line of cases from the 1960s and 70s in which the courts drew lines around certain kinds of government surveillance. Subpoenas issued to the NAACP saying that you can't issue a subpoena, you can't force the NAACP to give up its membership list unless you have a very good reason for demanding that it do so. Because that kind of demand, that form of, it's a form of surveillance, that kind of demand will inevitably have a chilling effect on the constitutionally protected right of association. And, you can see that line all the way through the 1960s and 70s. The Supreme Court, dropped it in the 1980s and 90s. But with, I think, more widespread recognition of the implications of new technology and a changing Supreme Court, we may see that line of cases, I think, revived in future decisions.
When Columbia University and the Knight Foundation, Lee Bollinger and Alberto Ibargüen, staunch defenders of human rights and the First Amendment, announced your appointment in the Institute, they pointed to the necessity in this shifting paradigm of protecting speech in the digital age. Mm-hmm. How do you see your work in the context of the surveillance, the secrecy, and privacy dimensions? How do you see this institute fulfilling its promise in a way that mm-hmm. protects these digital spaces in a way maybe they're not protected right now?
Mm-hmm, mm-hmm. Yeah, I think that it's important to recognize that these same technologies that I have thus far been describing as a threat also have a lot of promise. They're social media platforms, for example, have enabled speech in a way that we couldn't even have envisioned a generation ago. And in many ways that's an amazing thing. And I would say the same thing about search engines or video, sophisticated. The kind of sophisticated video technology that you were talking about when you're talking about the resolution of these investigations into terrorist attacks. All of those technologies can be used for surveillance, but they can also be used for many other things, and many of those things are positive. So I think it's a mistake. It would be a mistake to approach all of that with without a recognition of the possibility as well as the dangers.
Now, what's going to be important here, as it is with the ACLU, is when you take on a client or a cause, you have to support the integrity of that person or that organization mm-hmm. and back it. In the case of Snowden, the ACLU signed up on board. Manning too. Mm-hmm. How are you going to, and this goes back to the original question, right? Yeah. How are you going to define the parameters of what is the kind of case that you will embrace? Because the WikiLeaks organization might not fit into your pedigree mm-hmm. for what is acceptable mm-hmm. in terms of defending those digital spaces. And
Sure,
as
right,
I understand it, Jameel,
Right.
one of the imperatives here is to put resources behind the defense of folks who may indulge in those leaks, who otherwise wouldn't have legal protection.
Yeah, well, I think that our mandate is to defend and expand First Amendment rights. The freedom of speech and the freedom of association, freedom of the press, and we will pick our cases so that over time we'll be picking cases that, in our view, shape the law in a way that expands those rights.
Wait, I just want to clarify. So how so? Expands, how would you like the rights
Well,
to
I'll
be
give you,
expanded?
I'll give you an example. I mean, there are cases right now involving the right of individuals to film government activity, especially film the police, right? So these are cases that obviously are very prominent right now because of the Black Lives Matter movement and all of the incidents that led to the Black Lives Matter movement. But that question of how far that right of individuals to film the police or to record and broadcast government activity, how far that right goes, I think is a crucial one. And I expect that we will fight for the expansion of that right. There are other cases involving other contexts in which what's at issue is government transparency in a more traditional sense, what the government has to disclose to us about government activity, about the reasons for that activity. And there, too, I think that we will push some of the limits that have been set over the last 10 or 20 years. The area I know best is national security. That's what I've been working on for the last 14 years. And there are, as everybody knows, many contexts in that sphere in which the lines that have been set result in the public having little or no information about the government's policy and the reasons underlying that policy. And there too, I expect that we will push those. We will try to push those limits. With whistleblowers, we talked a little about this already, but I think that the use of the Espionage Act to go after people who have disclosed information, not to foreign intelligence services, but rather disclosed information in the public interest to the American press, because they believe that what they were disclosing was reflected abuse or reflected overreach. I think that a statute that fails to distinguish between those two sets of people should be viewed as constitutionally suspect at the very least. Now, drawing those lines is not an easy thing, and you're right that in any individual case, we may not have the perfect set of facts. It's not news to anybody that in the First Amendment cases, especially, sometimes the clients are not the clients that you would have dreamt up if it were sort of within your control to dream up the ideal client. First Amendment cases are often cases that involve, in some sense, bad facts, right? Because the First Amendment was meant to protect people at the margins. It was meant to protect the people who were controversial, who everybody else disagreed with, who everybody else thought were offensive, or those are the cases that have always shaped the First Amendment and always influenced the development of First Amendment doctrine. And we're going to be, among other things, First Amendment litigators, and I expect that we will take cases in which not everybody will like our plaintiffs.
Isn't it more difficult than ever, Jameel, to disentangle the potential of foreign espionage in the case of cyber attacks from Russia? Mm-hmm. There is increasingly scrutiny that ought to be placed on prospective clients to ensure that they are not working with the enemy, is a cliche notion, but they do not have ulterior motive. Isn't that a reality of the cyber war that is not just haunting us, but it is a reality that we are not aware of when we go on our Gmail and our day-to-day digital footprints? We don't see it, but it's happening.
Yeah, I mean, I think that that's right. I mean, I think that there's a certain amount of diligence that any lawyer would want to do, given the murkiness that surrounds espionage and and national security leaks. So I think that's right. The one thing I'll say is that, our clients, in some cases, may not be whistleblowers. They may be the people who are publishing what whistleblowers provide. And there, I'm not so sure that motive actually matters. I think that when the New York Times gets information from a leaker, the question that the New York Times should ask, or certainly the principal question that the New York Times should ask, is the disclosure of this information in the public interest? And the motivations of the person who provided them the information, I think that those should be viewed as secondary.
And finally, you do heed a notion of balance in your answer about what this definition means today, an idea that we're not going to acquiesce to national security necessarily or to speech. As you look to the Supreme Court as the law of the land, what is your hope in this upcoming term that the court might say, and we're running out of time, but in, again, redefining speech in a way that is more effective if it's not going to be espionage? What is the channel through which the court can determine there is permissible challenge to speech?
Yeah, I think that there will be a set of cases involving government whistleblowers. It may take several years before they get up to the Supreme Court, but that will be about the significance of the public interest in those kinds of prosecutions. There'll be a set of cases involving government surveillance, which will have First Amendment implications, and my hope is that the court will actually engage with those implications rather than pretend that they don't exist, which is sort of what the court has been doing for the last 20 years. But I think that those are two areas where you will see the development of First Amendment law relating to issues that are distinct to our digital age.
Jameel, congratulations again on the Institute, and thank you for being with me today.
Thanks for inviting me.
And thanks to you in the audience. I hope you join us again next time for a thoughtful excursion into the world of ideas. Until then, keep an open mind. Please visit the Open Mind website at 13.org/openmind to view this program online or to access over 1,500 other interviews. And do check us out on Twitter and Facebook at Open Mind TV for updates on future programming.
Continuing production of The Open Mind has been made possible by grants from Anne Olnick, Joan Gans CUNY, the Engelson Family Foundation, Alfred P. Sloan Foundation, the John S. and James L. Knight Foundation, Carnegie Corporation of New York, May and Samuel Rudin Family Foundation, Joanne and Kenneth Wellner Foundation, Rosalind P. Walter Foundation. With special thanks to the Schumann Media Center for additional support, and to the corporate community, Mutual of America.